Dr. Kaur, can you please briefly tell us about this act and how it was different previously, how the data collection was different previously compared to now? So just a little brief about this act. Yeah.
Okay. Hi, everyone. So before we diverge into the act, I'll give you a little background. So in 2017, case happened in the front of Supreme Court, and a 9 bench said that nothing could be more deleterious than a calculated interference in individuals' privacy. So it acts down as a major foundation on which the whole premise of the Privacy Act was based. So right to privacy is a fundamental right to us. But, in India, for various reasons, this continued to be as a bill only. So we had a bill in 2019, it was stable, it had some clause like data localization and it could not pass basically. So in 2022-23, this bill was introduced, popularly known as DPDB, which is Digital Personal Data Protection Bill. And it finally got an assent from President on August 11, and it became an act. So what this act basically means, it empowers the individual to have a right over their data. Similarly, it empowers the organization to process the data only if they're doing it legally. So it gives two specific rights. One is the right over the data they are sharing, and that needs to be done with the help of a consent. I mean, if I do not want to give my consent, nobody can use my data. There was nothing short of this existing in India. And that is why even if you're sharing your data with a mobile company and you end up getting call from recruiters, you end up getting call from insurance company. So no form of consent has been taken from me if my data is being shared with different processes. So this act very strictly lays down that you have to gather consent, and it has given very specifically, it has said that you have to make an itemized quote when you are making the consent or you are taking the consent. So this itemized means you have to specify all the reasons or all the needs or all the places where this data would be shared. This is something very unique, that it has asked for an itemized list of reasons for which the data would be processed. And like any other law, like GDPR, it would be providing us with certain rights, like we can have a right to delete our data, we can have a right to access our data, and with a unique right called right to nominate, which we can later on discuss. So overall, this is our first act which protects individual rights. It gives us the power to not to be coerced into giving our information to somebody if we don't want. Yeah. So it empowers us with our fundamental right to privacy precisely.
Very nicely put. Like, it gives us the power to handle our data. Like, if we want to give consent or not, we can't be forced to, be obligated to whatever has been asked. Very good point.
The beauty of the act is it has actually explicitly said that it should be a free consent. So you cannot use dark web patterns, or you cannot, pre-tick anything and said that we had already sent us. So it has to be free. That's the beauty of the act. Yeah.
Could you also tell us like some of the key requirements that are needed, in order to collect this data?
So I'll give you 2 instances here. As a data fiduciary, as a data principal. And so the act actually have introduced 3 new terms in general. Data fiduciary. A fiduciary means the one with whom you entrust your data, right? So all the companies who are connecting data are termed as data fiduciary. In general, GDPR, this term is data controller. So most of the act have gone with the term data controller, but we have gone with fiduciary. So adding more trust to the word data fiduciary. The second thing is data principal, commonly known as data subject, from whom the data would be collected. The third party that the act has introduced is a consent management, basically an entity that will be registered with the board, data protection board, and that would be acting on behalf of data subject. So while so for example, we are talking with the HR industry, and it becomes specifically better to understand because that's the least talk, right? So for HR company, if you are hiring or collecting information from person who are either your prospect or become an employee, you have to be very meticulous in cataloging this data. So as of now, I do not understand that the HR industry or the HR department is cataloging the data or taking any further step in storing the data. or defining a retention period, or making any mechanism if an employee wants to access the data, right? Or if as an employee, I want my organization to delete my data or make a rectification of my data. Or if I intend to ask to how many data fiduciaries you have shared my data. So all these things have never been thought by the HR industries, right? So this is how you have to now think every time you are collecting an employee data. You have to catalog the data on the basis of how long you're going to share, store it, how many processor or fiduciaries you're going to share it, and and what organizational and technical measures you're going to employ to safeguard the data. So this is how the act is empowering us.